document meets the statutory requirements. And there are certain requirements about what language needs to be contained in a document that is being filed. Of course, the document has to be filed and be in English language. The document must state the section or sections of the organic statutes upon which you're relying on getting the document for filing with the Secretary of State. And if you actually go on the website, there are sample documents for whatever you need to do. And those documents will actually reference for you those statutory provisions. But sometimes when you're filing a document, there is an option to attach an additional attachment as required by statute, or as you may wish to provide additional information which may or may not be required by law. But generally the law is that whatever is required, your document must state, and you don't have to provide additional information. As part of the document that is being filed with the Secretary of State, you also must tell the Secretary of State who is the person filing the document and what their contact information is. So you need to list that person's name and address or addresses. And finally, you need to figure out what the effective date of your filing document is going to be. Most of the time, the effective date is the date you're actually doing the filing. So the minute you hit submit and you've provided a payment, the system, Colorado Secretary of State electronic filing system, is going to take a while, but it's going to accept your filing, and it's going to assign a date and time when your document was filed. You can, however, select what we call a delayed effective date of filing. So for certain reasons, you do not want your filing to become effective right away. So you can select a future date, 5 days from now, 10 days from now, 15 days from now, and you simply indicate that date on the actual filing. What happens if, let's say, you've indicated that you want your document to be effective 15 days from now, and 10 days from now you decide that, hey, I do not want to file this document? You can actually contact the Secretary of State, better to do it in writing, and actually tell the Secretary of State that you want to withdraw that filing. If, however, the filing has taken place, then you can file what's called a statement of correction, withdrawing or revoking the filing, so long as that is done within 90 days from the actual filing. Now, the statutory provisions, and those are the Colorado Revised Statutes, talk about different general definitions. And actually that is the statutory provision 7121-401. And it gives you a whole list of terms that you may need or want to know. And the four that I have pinpointed as important, and I'm going to talk about today, are the Articles of Incorporation, the Board of Directors, the bylaws, and what does it mean to be a member. So Articles of Incorporation is the document that gets filed with Colorado Secretary of State to get your HOA incorporated as a nonprofit corporation. The term Articles of Incorporation also includes amended Articles of Incorporation or restated Articles of Incorporation. Now, who is the Board of Directors? The Board of Directors is the governing body of your organization. Bylaws. And you may be familiar with the term, but the bylaws are the operating document of the nonprofit organization. The bylaws tell how the organization functions, how it is managed, what its duties, purposes, powers are, who are its members. And I've actually seen documents that sometimes are titled something else but bylaws. But at the end of the day, they are bylaws because they are the organizational document of the nonprofit organization, in this case, the HOA. And finally, member. Member means any person or persons who are identified in the Articles of Incorporation or the bylaws or in a resolution that is adopted by the Board of Directors. One question that I get once in a while from some of the HOAs that I work with is, how do we give notice to members? And when is notice effective? Notice can be given in person, telephone, telegraph, email, any wireless communication, by mail, by personal courier. In order for the HOA to give sufficient notice to its members, it has to use the current address of the member or members that it has on file in its records. And what the statutory provision in Colorado says is that if 3 consecutive notices that are sent to a member come back as undeliverable, then the nonprofit corporation or the HOA does not have a duty to continue sending notices to that member or members until the member or members provide new current contact information that the nonprofit can put in its records. When is notice effective? Notice is effective upon receipt or if sent by first-class regular mail on the 5th day upon sending, and again, we're gonna have to look at when the notice was postmarked, so long as it was sent to the correct address. A notice can also be sent by certified mail, return receipt requested, or registered mail, and it is effective when it is signed for. If none of those means are used, then the notice is effective upon 30 days of when it was sent. Now, who are the incorporators? The incorporators can be one person or more persons. The statutory requirement is that whoever the incorporator is, it's a person 18 years old or older. Now, I briefly mentioned the Articles of Incorporation. We have a statutory provision, and that is 7122-102, as noted in your outline, which specifically says what the Articles of Incorporation must say, what information needs to be contained. And what is required is the true name of the nonprofit organization, corporation, in this case the HOA. The registered name and the address of the registered agent. In Colorado, every entity that is formed through the Colorado Secretary of State must have a registered agent. What is the purpose of a registered agent? A registered agent can be a person, and when I say person, that can mean individual or a company or an entity, who is readily and easily available for purposes of service. So if somebody wants to serve your HOA, they will usually go through the registered agent. The registered agent, again, can be a company, a person, it can be a lawyer, it can be the executive director or the manager for the HOA, etc. So long as that person is easily available, that makes the process easier, and it also suffers the intent of the statutory requirement to have a registered agent. The other required information in the Articles of Incorporation is the name and address of the incorporator or incorporators. It does not have to be the persons who are setting up the HOA. Sometimes for purposes of confidentiality, if you look at Secretary of State records, you will see that actually attorneys are listed as incorporators. We can do that. But again, most of the time it's done for confidentiality reasons, because we may not want to know, we may not want to tell the public who the client or the incorporator behind that entity is, or the client may have specific reasons of why he, she, or they do not want to put that out there as public knowledge. The other requirement is to list and state whether there are going to be voting members or not. And the final requirement for the Articles of Incorporation is to tell what happens to the assets of the HOA if it is dissolved. Now, the rest of the items that I have listed is information that you can include in the Articles of Incorporation, but it is not required. That is, who are the initial directors, their names, their addresses, what are the purpose or the purposes of the nonprofit corporation, in this case the HOA, how is it being managed, how is it being regulated, what are its powers, is cumulative voting permitted or not, and what are the members' rights and the obligation. So once the nonprofit corporation is incorporated, then the process is to determine that the articles of incorporation list initial board of directors or not. Now, stepping back for a minute. So at the time the Secretary of State accepts the filing of the articles of incorporation, that is conclusive evidence that whatever requirements there were as prerequisite for the incorporation have been met. So now, the incorporation has taken place. So what you need to determine is whether there were initial directors named in the articles of incorporation or not. If there weren't initial directors named, then the incorporators must meet. And that takes a majority vote of the incorporators. And what their job is to adopt bylaws, again, the operating document of the HOA, and elect a board of directors. If the articles of incorporation did name an initial board of directors, then now the board of directors must meet. Again, it requires a majority vote of the board of directors, and they will meet, they will adopt the bylaws, they will usually appoint officers, and then they're gonna get to the business of the nonprofit corporation. Who gets to prepare the bylaws? Generally, those are drafted by council. Who gets to adopt them? The bylaws will be adopted by the board of directors, if there is none, by the incorporators, and if that hasn't been done, the members are the one who must and will adopt bylaws. Now, the statutory provision in Colorado talk about emergency bylaws, and that's noted in your outline as well. What the statute says is that an emergency exists for the purposes of what we're talking about if a quorum of the directors cannot readily be obtained because there is a catastrophic event. And if that happens, then emergency bylaws, for whatever the issues are, could be adopted. Now, what are the purposes and powers of a nonprofit corporation? Every nonprofit corporation in the state of Colorado engages in lawful business or activity unless a more detailed purpose is listed in its articles of incorporation. The more fun talk for me is to actually talk about the general powers that a nonprofit corporation has. Stepping back for a minute, unless otherwise provided in the articles of incorporation, nonprofit corporations have perpetual existence. And when talking about the powers of a nonprofit corporation, think of it this way: they have the powers that you and I have sitting here today. So just a brief list of those powers. They can sue, they can be sued, complain, defend in their name. They can make and amend bylaws. They can purchase, receive, lease, or otherwise acquire personal property as well as real estate. They can sell, mortgage, lend, pledge, personal property, real estate. They can enter into contracts, agreements. They can lend money, invest, reinvest funds. They can also donate, like to a charity. They can be an agent, associate, trustee, manager, member, partner. They can conduct whatever activities are required for the business of the nonprofit corporation. They can open offices. They can do that in the state of Colorado. They can do it outside of the state of Colorado. They can elect, appoint directors, officers, employees, agents, legal representatives, whether that be attorneys, CPAs, etc. They can pay pensions, establish pension funds, profit sharing, other benefits, incentive plans. They can impose dues, assessments, admission, transfer fees for their members. They can also impose conditions on what it takes to become a member in the nonprofit corporation. They can indemnify their current former directors officers, employees, fiduciaries, and agents, and they can also limit the liability of their directors. And finally, they can cease to do business. And again, if there is an emergency, and I've already talked about what emergency means, then emergency powers can kick in as well. Now, there is an interesting concept. It's a legal term that's called ultra vires. What does that mean? It means that the validity of a corporate action may not be challenged on the ground that the nonprofit corporation lacks or lacked the power to do what it did, unless there is a petition that is brought against the nonprofit corporation, and usually that is done by a director or a voting member or voting members. And this is what we call a derivative action. That is the legal term for that. Or a proceeding on behalf of the nonprofit corporation, and that is usually brought by a trustee, a receiver, a legal representative, and again can be direct or derivative. Or the Attorney General could bring a legal proceeding. And if any one of those three instances, a court of competent jurisdiction can actually set aside the act of the nonprofit corporation and can also impose damages. Now, there is a specific statutory provision which somewhat imposes or limits not so much the actions against the nonprofit corporation, but what happens if there is a judgment against the nonprofit corporation. And that is statutory provision 7.123.105, which is titled Actions Against Nonprofit Corporation. And what it says is that a nonprofit corporation can be immune from levy and assessment and execution on any judgment unless it will be reimbursed by proceeds of liability insurance policies carried by it or levy and judgment actually executed against its assets. So it provides an extra step of protection. The last topic that I want to talk about before I turn it over to Leonard with regard to what it takes to incorporate an HOA is what if the articles of incorporation and or bylaws need to be amended. It is certainly doable. The articles of incorporation can be amended, so you can add provisions, you can delete provisions, you can amend provisions. And understand that a member does not have a vested right because of the articles of incorporation, because of bylaws, especially when we're talking with regard to management, control, purposes, or duration of a nonprofit corporation, and again, that means an HOA. Now, what happens when the articles of incorporation are amended? An amendment to the articles of incorporation does not affect the rights of others except for its members. What if there is a pending proceeding against the nonprofit corporation? Will the amendment of the articles of incorporation change that? No. What if the nonprofit corporation decides to change its name and there is a pending proceeding? Will that affect the proceeding? It will not, except for maybe a motion to amend the name of the party, in this case the nonprofit corporation that is involved in the legal proceeding. Bylaws. Bylaws can be amended as well. And who usually has the authority to amend the bylaws? It is the board of directors and or members. The board of directors may have certain restrictions with regard to amending the bylaws and what the board of directors can amend. Usually those restrictions will be imposed either by the Colorado Revised Statutes or by the Articles of Incorporation or sometimes the actual bylaws. Also, if the board of directors tries to make amendments which will actually limit the rights, the privileges, the preferences, and restrictions of the membership, that needs to be taken to the membership in order to make those amendments of the bylaws. The members can always amend the bylaws. When talking about amending the Articles of Incorporation, you will see there, I referenced a statutory provision which said that sometimes there is a requirement for a third-party approval. You don't see it often, but sometimes it's there. If such requirement exists, then the HOA, the nonprofit corporation, needs to make sure that that third-party consent to the amendment is obtained. And finally, when talking about amendment that relates to terminating members or redeeming on canceling membership, that is definitely an issue that needs to be taken to the members. They need to be given notice before such amendment actually takes place. Now with that, I'm going to turn it over to Leonard.
A lot of information. I'm sure.
That was the boring piece of
I ain't learned anything even after
So-
35 years. I was thinking, I guess just following on, and in my outline, I'm gonna very
We'll
brief.
answer questions after we finish, so just remember what your question is.
No problem.
Okay.
Okay. In my outline, I list the Colorado Nonprofit Corporation Act, and I just wanted to follow on to what Gina said, and that is some of the issues in homeowners associations involve the bylaws. And I think it's important to understand who can amend the bylaws and what amendments need to go to the members. Because I know some of the older bylaws say that the board of directors can amend the bylaws just in general. And that's not the case under the Nonprofit Act. The other thing is, that I mentioned under the Nonprofit Act, is that there's a very recent case, and Lauren knows about this, the case where a Colorado Court of Appeals judge ruled that any amendments to the declaration needed to follow the Nonprofit Act procedures. And there's a great deal of confusion on exactly how that interfaces, because most of your covenants, your declaration of covenants, say you just circulate a petition around the neighborhood, people sign up to amend your covenants. Well, the judges in the Triple Crown case said, well, wait a minute, no, you can't do that, you've got to do it under the Nonprofit Act procedure, which has some time limitations and some other requirements on it. And the third thing I'd mention out of the Nonprofit Act discussion is that those of you that are on a board or thinking about being on a board, make certain that your that your articles and your bylaws contain those indemnification provisions that Gina mentioned, because you're volunteering your time, and if there's a lawsuit against you, you want to make certain that the association is going to stand behind you. That is not a substitute for insurance. You need to make certain, if you're serving on a board or going to serve on a board, that your association has what's called D&O insurance, Directors and Officers Insurance, or it's sometimes called Association Professional Insurance. And you should get I recommend you get from your insurance broker a letter that you have that kind of insurance. Most of you, if you have homeowners insurance, also can get umbrella insurance, which will cover you also. There can be double coverage, but it's better to have double coverage rather than no coverage. And we're involved in litigation right now where an insurance company that will remain anonymous is refusing to defend our volunteer nonprofit board members on a fairly substantial case involving, depending on how you look at it, anywhere from $50,000 to $1.5 million in claims. And so it's very important that you look at your articles and bylaws and that they have indemnification, and that you get insurance that covers your instructors and officers. So my topic is how do HOAs operate, which is probably a topic we could talk about all day and share war stories about how that occurs. As I said, I've been representing HOAs for about 35 years, 40 years. During that time, I've lived in an HOA in Rock Rimmon. And I've always been able to avoid serving on the board of directors. I'd sort of let Charlie do it, let somebody else do it. And for many, many years, we had a retired Air Force colonel who ran it like a military operation and did a terrific job. He retired and moved to San Antonio, Texas, and there seemed to be a power vacuum for a while. They couldn't get anybody to serve, so last year I broke down and said I'd serve on the board of directors. I've been to a lot of board meetings in 35, 40 years, and I thought I knew everything about how board meetings operate and how much time was involved. But all I can say is being on the board of directors is just one of the most time-consuming things that I've ever done. It exceeds in many ways my law practice and being on church boards or Boy Scouts or whatever. And it's quite contentious in many regards, and it's quite high stress and high strain. So the focus of my talk is to sort of give you an overview of how HOAs operate, give you some maybe some suggestions, talk about maybe one example that's currently a hot topic of vacation home rentals or vacation rentals. And we could talk a little bit about that and how this all fits together. So going through my outline, there are three areas that you need to consider when you're operating an HOA. And these are typical whether you have a single-family HOA or multifamily, like condos or townhouses. So it's just generic to those. Those different types of HOAs do have different procedures and policies and operations, but I tried to take it at the general level. The very first level you need to consider if you're going to be on a board or if you are on a board is read your documents. I'm often amazed at how many homeowners don't read their documents, but then it's also a problem if the board members don't read the documents. And most of the documents, even going back to the 1960s, 1970s, have fairly good provisions in terms of the covenants and the restrictive uses, what's prohibited. They may be a little bit light, and they need to be updated on the Articles of Incorporation and the bylaws of it, because those laws have changed. Even as to the covenants, the laws have changed under the Colorado Common Interest Ownership Act, or Kiowa, which I'm going to talk a little bit about later on. But I often tell associations that the place to start is to read your documents. And the documents are really a pyramid of power, so to speak. Your covenants, or the declaration, or CC&Rs, we often call, those names are all synonymous, interchangeable. The covenants stand at the top of the pyramid. They are a document that's recorded in the real estate records. So any homeowner who buys into an association and claims, I never saw the covenants, is very forgetful, let me put it bluntly, forgetful. Because they're recorded, they show up on everybody's title when you buy your units. And they contain usually the basic operating procedures for covenant enforcement, which typically, I mentioned already, restrictive covenants. What uses are prohibited, what uses are allowed. They will recognize the creation of the association as a nonprofit. They will refer to the obligation to pay assessments, dues. They refer to sort of basic, essential operating procedures within your association. They may be amended, but as I said, this recent case seems to indicate that you have to comply with the Nonprofit Act to amend them even. They are really your basic first document to read. Then you have your Articles of Incorporation, which Gina's already talked about, filed with the Colorado Secretary of State, creates certain basic provisions on the operation of the homeowners association. Then you have your bylaws. Bylaws are the corporate operations manual for your association. They usually tell what kind of notices have to go out, how the notices will be given, the timing of notices, meetings of owners, meetings of the board, how many people you have on the board, how the terms of the board are arranged, the powers and duties of the board members, and then the powers and duties of the officers, the president, vice president, secretary, and treasurer. All of those are usually set out for the really operational procedures in your HOA. The final, on the base of the pyramids, and most associations have these, are the rules. The rules can be sort of operational rules like parking rules, no parking in the fire zone. Or they can be rules that involve the operation of members and members' rights, such as the procedures for fines and hearings. There is I just mentioned here, there is a statutory override if you're under the Colorado Common Interest Ownership Act, Kiowa, which is in this red book. You must have the so-called 9 policies. And what they call policies, or governance policies, is synonymous with rules. One of those is your procedure for having hearings on imposing fines. Another one is how you collect assessments. Another one is how you handle conflict of interest, how you have reserves or reserve studies. All of those are set forth in the statute, and they're mandatory for Kiowa associations. If you're not under Kiowa, if you're exempt from Kiowa, then you don't need to have those, but they may be recommended because they do cover certain essential areas of operation. So really, that's how the structure of your legal documents at the basic level operate. So let's take the example of vacation rentals. Let's suppose one of your homeowners wants to use their house or their unit for a vacation rental. By vacation rentals, we mean a situation where it's not your typical leasing, where they do it for 6 months or a year. It's where they do it usually on the internet, and they usually do it for a very short period of time. I've even seen them for a few days, a weekend, parents' weekend at the Air Force Academy. Or 2-week vacation rental, come to Colorado. Is that allowed by your documents? Can they do that? Because it often generates traffic, parties, noise, broken beer bottles on the front lawn, parking in your parking spaces, problems for the association. I'm seeing a lot in probably more single family than maybe multifamily. It hasn't risen that much. And the estimates of the number of vacation rentals in Colorado Springs range from a few hundred to a few thousand. It's become a popular investment mechanism for people that cannot sell their houses, or I think there's even some of these real estate gurus that are promoting vacation rentals. I also have a property down in Scottsdale. It's just rampant out there during the baseball season. That's all there are. So how would we approach it? How would you approach whether your neighbor is allowed to do a vacation rental? Well, remember I said the first thing to look at is your declaration. Most declarations say that the units or the homes are limited to residential use. Is a vacation rental residential use? How many think it's a residential use? How many don't think it's a residential use? Okay. Well, unfortunately, the courts don't agree with you. Most of the courts say that a bed and breakfast or vacation rental type thing is a residential use. But then a lot of your declarations have another couple terms in front of that. Single family residential use. If your covenants have those magic words, single family, there is case law in Colorado that does not allow multiple family use. And it seems to indicate, although maybe Lauren's firm has litigated this, but we haven't litigated it, the vacation rentals are not single family uses. Especially if they use another magic word, private single family residential use or private residential use. There's case law that is more restrictive than just residential use. And it has to be a prohibition on use rather than on building type. Some of your declarations have that only single-family buildings are allowed. And the courts in the question of group homes have said, well, if it looks like a single-family home, it can be used for a group home. That isn't a use restriction, that's a building restriction. And I think that's a double D case, the double D case. But having said that, then sometimes we have to look at another provision in the declaration. And most recent declarations also have a leasing provision. Typically, a leasing provision in the declaration says units may be leased. So that sort of indicates there can be vacation rental. But then in the leasing provision, it says any terms of the lease shall be at least 30 days, or some say 6 months. Can you amend your declaration to say will be no vacation rentals? And the general answer is that there's no Colorado Supreme Court case on this, but the Colorado Supreme Court has indicated that amendments can be, in associations, can be done for any reasonable purpose. And there's considerable case law in other states that you can restrict rentals with amending your declaration. Can you just adopt a rule prohibiting vacation rentals? Well, remember that pyramid. The pyramid is that the rules cannot conflict with any of the documents up above. So if if the declaration said people can rent for vacation rentals, you can't adopt a rule that says people cannot rent for vacation rentals. On the other hand, if your declaration is just open, it just says residential uses only, it is possible that a court might consider a rule that would define residential to require either a particular term, namely 6 months, 1 month, or so on, or maybe prohibit what would be, quote, commercial activities. Because if you look in your declaration, there's probably, on the one hand, it says residential uses are allowed, and on the other hand, it says no business or commercial use. And so you say, hey, vacation rental is like a motel that's sort of in our neighborhood, and it's commercial use. Looking through that, then, if you talk to the lawyers will give you the most conservative view, not politically, but most careful view would be that your best approach is to amend your covenants because they stand at the top of the pyramid. So if you don't want vacation rentals, if you don't want marijuana grow houses, if you don't want group homes, subject to the Fair Housing Act, which Lauren's going to talk about, you need to go around your neighborhood and amend your declaration, always complying with the Nonprofit Act, as Gina mentioned. So, tell me when my time's up, because I don't want to talk too long in Lauren's time. I get wound up here, and I could probably talk all day on this. But what you understand and how the operation is, we're just talking at a basic level, at the level of changing our documents, or reading our documents first, or changing them if necessary. So let's go to the next level that you have to be concerned with, and we've already talked about the Colorado statute called the Nonprofit Corporation Act. It has nothing to do with rentals, but it does have procedures on indemnification and amendments. The Colorado Common Interest Ownership Act, which I've already mentioned, Kiowa, like the street, although with a C rather than a K, does not mention vacation rentals either. But it does have a lot of provisions that talk about the operation of owners associations and your powers and duties as associations and as boards. And it does allow that the board can enforce the covenants, it can impose fines, it can do a number of things. One of the open questions, though, is, and this is a bit on Gina's talk, is Kiowa does supersede all other statutes. It's the supreme statute in the statutory pyramid. If there's any conflict with the Nonprofit Act, Kiowa controls. And Kiowa does have certain provisions that do talk about bylaws, they do talk about articles, and they do talk about amendments, and they have amending procedures. And one of the issues is talking again about where you could prohibit vacation rentals. Is the argument is that Kiowa may require that be in the declaration rather than your rules or bylaws. And so that's something that they'd be concerned with in complying, even though the Colorado Supreme Court in the Evergreen Highlands case said you could amend for any reasonable purpose, you still have to look at the statutory provision of Kiowa, which may require that the amendment be done in a certain document or not. So now we've complicated your life by having to read the declaration. Then you have to read the statute that's 50, 60 pages long. And Kiowa is amended about every year, and one of the amendments is going to occur this year, we hope. It's going to be signed by the governor in a few weeks, is that small associations won't have to follow Kiowa. And those small associations may impact a lot of the older associations where the annual assessments per unit are $300 or less, plus $300 plus insurance. So it can actually go beyond $300. If that's signed, then a lot of those requirements of Kiowa will no longer burden. The legislation that's also being proposed and worked on is to exempt small associations from manager licensing. And Lauren's going to talk about manager licenses. So I won't talk about that. Final one is the court cases. Just so you know, after you've now read your documents, you're now thoroughly versed in all these pages, along comes the Colorado Court of Appeals or the Supreme Court, and they say, oh, by the way, this is how we define residential use. Often courts will look at not only your documents, but they'll look at other sources. And those other sources, one primary source for judicial interpretation of the documents is the zoning code. Colorado Springs does have a provision in the zoning code that may restrict somewhat vacation rentals. There's an interpretation, and I've given this to Kono, and they may put it on the website. I'll try to make certain they do it. It was back when Dick Vanderwalt was the head of that. When did he do this? In 09, it looks like, December of 09. And so there may be a basis to go to the zoning authorities and get the zoning authorities to prohibit vacation rentals, group homes, foster homes, drug and alcohol treatment centers, marijuana grow facilities, medical marijuana, we could go on and on. The court cases generally talk about the same sort of things we've talked about before in terms of rights and duties of owners. The members' rights to participate, to be at board meetings, to be voting, to approve amendments and those. Where the court has given both good news and bad news is in board members. If you're on a board, you're subject to what's called fiduciary duties. Fiduciary duties are a standard of care where you cannot simply go on your own self-interest, but you have to consider the interest of the entire organization, the entire association. And fiduciary duties are often imposed upon trustees, persons in positions of trust and obligation. So the courts have said board members must meet a higher standard of trust and care than simply ordinary homeowners. That's the bad news. The good news is that the courts have then said that these are volunteer, unpaid volunteers, and so they deserve protection under the laws. There is a statutory provision both in the Nonprofit Act and a General Volunteer Immunity Act, which gives you immunity. But the courts have generally held that HOA boards are under the business